Welcome to the Great Trials Podcast. This is Steve Lowry with Yvonne Godfrey. Yvonne, how are you doing this afternoon?
I'm good, Steve. How are you?
I am good, and I want to show you. We had our the Savannah office White Elephant Christmas party, and so I was just going to show you what I got. It's called the Chicken Flickin' Desktop game. Like you shoot this chicken like this, like a rubber band.
Oh.
At these cups.
So what you're saying?
That's what I'm going to be doing after we get off.
Yeah. So what you're saying is there was an office party that I was not invited to.
I'm sorry, it was just for Savannah, and you decided to move to Atlanta.
Okay. All right. Nobody gave me presents up here. That's all I'm saying.
Right.
Well, anyway, you know what? My present is the presence of our guests.
That's
today.
right. We do have some fantastic guests today.
We do, and we're continuing with a trend, Steve, because
Yes.
our last episode was a father and sons team. And we have a stellar father and son team from Houston, Texas on the show today. We have Jim M. Perdue Sr. and Jim M. Perdue Jr. So, Jims, thank you for being with us today.
Our pleasure.
My pleasure. Glad to be here.
Well, so let me tell our listeners a little bit about who you are before we get into the case that we're here to talk about today. We have so much good stuff to talk about today that I really can't wait. So you can look up both Jims at PerdueandKid.com. That's PERDUE and kid with 2 Ds .com. Jim Perdue Jr. is a partner there, and Jim Perdue Sr. is of counsel now because he's busy about doing a million other different things, which we'll talk about. I'm gonna pick on Jim Sr. first and tell our listeners a little bit about him. He got his bachelor's and his JD from the University of Houston, and Forbes once called him the king of malpractice lawyers, which I feel like has got to be one of the most impressive titles we've had on the show, Steve.
It's great. I'm just wondering that when you go into the doctor's office, are they, wait a minute, hold on, the king
Hold
of
on.
No, but that is a fantastic title.
It's awesome and well-deserved. Jim Sr. has been quite the trailblazer in plaintiffs litigation, especially in Texas. Just some of the things that he was one of the first to do is to use things that we all do now like it's routine, but he was one of the first to do a lot of these things, to use an economist to help establish a plaintiff's lost earnings and future earnings, to use a life care planner to help project the future costs of medical care, to use a working scale model demonstrative in a case, to use a real-time demonstration of a nursing procedure. These are all things that he was kind of, the first to try that many others have sort of adopted. He's gotten many fantastic verdicts in products liability and medical malpractice, among others. But as I was mentioning earlier, go ahead.
I was just going to say, I am almost 50 years old, and Jim Perdue Sr. has been getting verdicts, $1 million verdicts since before I was born. So that is a long time and been doing great work.
Pretty amazing. He is also an author. He's written numerous legal treatises on Texas medical malpractice, Texas product liability law. And he's also done a lot of books on trial techniques and jury persuasion. One of them, Who Will Speak for the Victim, I know somebody has talked about on the show before, Steve.
Yeah, it's a very well-known book, and we are so glad to have Jim on.
Yes. Who Speaks for Justice, that's another one of his books, using the narrative to persuade in trials, speeches, and lectures. And he's got an upcoming book. Am I allowed to talk about that, Jim?
Sure.
Okay.
Well, we're working on it diligently.
Too late now.
I wasn't sure if that was a secret. We had to edit it out.
Right.
He has an upcoming book that's going to be on lessons learned speaking for the victim. So we will all be looking forward to that. He also began teaching a course at the University of Houston called Storytelling, that we were talking about before we recorded, because it's really a lot different from, I think, what's typically taught. And I know you're teaching a whole class on it, so we can't cover it we can't cover all of it in this episode. But Jim, I'm just hoping you could tell our listeners a little bit about what you teach in the class, or why it sort of fills this gap in things that people are not being taught.
Glad to.
Yeah.
Can we do it now?
Yeah, hit me. Hit me. Give us the somehow try to give us the abbreviated version.
Well, I'm going to keep this awfully brief, but this is something I believe that a trial lawyer has to be dedicated to the proposition you never quit learning. You never quit getting better. And so over the years of trying cases, I learned that a trial is not a debate. And I was a debater in college, like a lot of people were, and a moot court participant. And it's just not a debate. A trial is a competition of stories, and the best story is going to win. And what I have found is there is a lot of talk in the legal profession today about storytelling, but a lot of people that say they are storytellers are not really storytellers. Because if you want to tell a story like an opening statement, it is not the story of the trial, but that's what people do. They get up and tell the story of the trial. It is the story of the case. And so in simple terms, storytelling is starting at the beginning with the case and telling it throughout the trial. And then in closing argument, maybe we'll have a chance to talk about some closing argument techniques, but it follows right on through. But that in essence is what I taught.
Well, it so comes through in the materials you sent us, and we'll get to it. But one of the PowerPoints you sent us was like so absorbing and interesting, which is really saying something for a PowerPoint when you're not even hearing anybody talk about it.
Right. Just the first like 3 pages, you want to figure out what happened. You've got to turn the next page.
Exactly. Well, so I've picked on Jim Sr. long enough. Let me also tell our listeners a little bit about Jim Jr. And I'm sorry if that sounds.
Lost everybody. Everybody's on pause. I couldn't hear anything.
Oh,
okay.
We can hear you now. Are you back with us?
It says my internet connection is unstable.
Okay.
So sometimes what can happen is that it might look like it's frozen to you. We're still getting it, and Raz will still record it. So we generally just talk through it unless Raz lets us know that something catastrophic has happened. So.
Well, if you're asking about those visuals, I invented the slide rule that we used. Fortunately, I don't still have a copy of it. It was introduced in evidence. We didn't get it back. Jim pulled out some of the visuals we had that we used during this trial, but it's kind of, I think we ought to talk about the case before we get into this.
Yes.
Yeah, absolutely.
Definitely. Well, so for our listeners, Jim Perdue Jr. Is a University of Texas undergrad and then University of Houston for law school. He is a many-time Texas super lawyer, top 100 attorneys in Texas, named one of the best lawyers in America for personal injury practice. He's tried over 30 cases to verdict, which is really impressive when you look at the kinds of cases that those are, with multi-million-dollar results in the areas of pharmaceutical liability, workplace injury, medical malpractice. He is board certified in personal injury trial law by the Texas Board of Legal Specialization, and he's board certified in medical professional liability by the American Board of Professional Liability Attorneys. He served on the Rules Advisory Committee of the Texas Supreme Court, which I can imagine is a very important and maybe thankless job. I'm not sure,
Right, yeah.
But very important. And I guess much like his dad, Jim also shares his knowledge at lots of legal seminars, and he also appears on TV. He's been on Good Morning America, Court TV, and local television as a legal commentator. And Jim, I'm interested, especially because I know, before we get into the facts of this case, I know there's a lot you must have learned from your dad, but what would you say is one of the main ways that you all are different in either how you work on a case or how you try a case?
So Dad and I were blessed to try many cases together, and there are a lot of differences, Yvonne, but one of my jokes is Dad and I tried a case in Atlanta, actually, in your hometown. It was actually during the ice storm of the Super Bowl, I think, 99.
Yeah.
And And my joke about that is we got a corporate apartment up on the north side of Atlanta. We were driving into town. We were trying a very tough medical malpractice case, and it's not a little thing. But my joke is if you can imagine going back to college and living with a really rich roommate who did not care what your schedule was. That was me living with Dad for 5 weeks, because Dad decompresses after a day of trial with a little bit of cognac and really loud classic movies on AMC till about 3 a.m. I wake up at 5 a.m. to prepare for the next day, trying desperately to go to bed at 10:30 or 11 and get some kind of sleep. So one of many differences as the approach of the grind of trial.
I love it. I love it.
That's great. That's very evocative. I think we all had some college roommate or friend where we can relate to that story. Well, so I'm going to tell the listeners a little bit about the actual case that we're here to talk about that you all tried. And then we'll get into what y'all can tell us about it, which is what our listeners really want to hear. The case.
And I think, Yvonne, we should note for our listeners, if I got it right, Jim, this is the first case you tried together, right? This case right here?
It was the last case we tried together.
Oh, the last case. Okay. I thought it was your first case.
Oh, it was the last case we tried together.
Okay.
It was the first case.
Okay.
Okay. Well, it's the case is called Alexander versus Battaglia and others. And we'll get into who those others are. It was a $3.6 million verdict out of the wrongful death of a patient who died as a result of medical negligence during routine orthopedic surgery. We talk a lot about a lot of our cases scare. I always say, Steve, that when we talk about cases that they scare me, but this is one that definitely scares me because it starts with, basic orthopedic surgery in Houston, Texas at Top Surgical Specialty Hospital. It's an outpatient facility. They have 7 operating rooms. They do about 7,000 cases per year. And in September of 1997, Mark Alexander, who was 40 years old, was scheduled to undergo arthroscopic surgery on his right shoulder. The anesthesiologist that was assigned to his case, Dr. Crowder, was not a full-time anesthesiologist and not one of the anesthesiologists. There were 2 anesthesiologists who had a contract with the hospital, basically an exclusive contract to cover those 7,000 cases per year. That's Dr. Battaglia and Dr. Polk, 2 other defendants in the case. You can't cover that many cases. They could not cover that many cases. So they had a part-time anesthesiologist, Dr. Crowder, who would also cover cases, who was not full-time and also not board certified, which is crazy. So she was assigned to this case. And so you're thinking that I'm done there. Well, I'm not really done there because Dr. Crowder really left Mark's anesthesia in the hands of a nurse anesthetist, a CRNA, named Constance Cernasek? I lost it.
Cernasek. Just go with it. Go with it. Yeah.
Constance, the CNRA. And she was assigned to Mark's case fairly last minute. It sounded like right an hour before the surgery. And we'll get more into the details. So Mark goes in for surgery and you can see where this is going. Mark basically gets, there are several mistakes, but he's getting inadequate ventilation during the surgery. The endotracheal tube is misplaced. He's not getting enough oxygen. As the surgery is proceeding, the alarm goes off at one point on the monitor. The CRNA calls in Dr. Crowder, the supposed anesthesiologist, who adjusts the monitor and then leaves again. Mark's heart rate isn't recorded for a period of about 17 minutes. And then eventually, my understanding is that the surgeon sort of notices that the curtain is kind of moving and asks the CRNA, like, what's going on? And she says she's not getting oxygen to one of the lungs, and Mark is blue at that point. He's been deprived of blood flow to the brain for 10 to 14 minutes. So he never wakes up. He ends up in a coma. He's transferred, and he's in a coma for 2 weeks before passing away on October 3rd, 1997. We'll talk about a lot of the things that Jim learned in investigating this case, but among other things, Mark and his family never met the anesthesiologist or the CRNA who actually did the anesthesia. And while Mark's suffering these complications and still alive, the hospital is unable to tell them who was providing the anesthesia, which is crazy. Anyway, so Jim get involved in the case while Mark is still alive, but in a coma. And so there's certain things in this case that they were able to do that you're not always able to do that ended up being really powerful in the case. So we'll get more into what they did at trial later. But in October of 1999, a Harris County, Texas jury unanimously found all 4 defendants negligent and awarded $2.88 million to Lisa, Mark's wife, and $360,000 each to Mark's parents, Ruby and Vernon, for a total verdict of about $3.6 million. A very significant result. I forgot to say this at the beginning, but people who listen to all our episodes know, but it's very important that they're in Texas because, as we have talked about, med mal's tough everywhere, but it seems like it's real tough in Texas. So a really terrific result from a really tragic case. One of the things that right before we recorded that Jim Sr. that you mentioned was how important preparation was in this case. And I think some of that probably relates to the fact that you all were contacted while Mark was still alive. So I'm hoping you can talk a little bit about, what those things, how you set this case up from the beginning, the things that you did early on once you were brought in on the case.
This case was referred to us through Vincent Elkins Law Firm, our biggest, one of our biggest firms in the city. I'm sorry for the dog.
We have them on a lot of our episodes. Don't worry about it.
Let me close the door.
Okay. We've got dogs. We've got leaf blowers. We've got.
Yvonne, one of the things I was thinking about this case is, why especially all of these cases are scary, but I think you, me, our partner Jeff, and our associate Josh have all gotten shoulder work done at various times. I've never had to have a surgery done, but I know that Josh did.
Yeah.
So it definitely we definitely have shoulder issues in this firm.
We do.
Yeah.
Well, to answer Yvonne's question, these people came to us through very high sources, which was. What can I say? You're flattered, you're honored when that happens, and you take on, at least I did, and I know Jim did too, an added responsibility or feeling of ability. When they came in, I did something that I hadn't been able to do in other cases. I had thought about it. But I asked the family if they had a phone recording system. And they did. And I told Lisa, would you please keep that tape of all the calls? Because I could imagine in my own mind dealing with a similar situation as this trial was going on, what it would be like, because people are going to be calling and asking. And so she did and brought it to me sometime later. I asked her to keep it, preserve it, and bring it to me. And it was one of the absolute most powerful pieces of evidence I have ever had. Now, think of it. We think, as lawyers, we think of visuals. And we know that the brain processes visuals better, remembers better visuals. we sometimes forget that sound. We had a couple of sounds in this case that I thought were powerful. One of them we may get to later, and that is the heart rate itself. But she did, and it was people calling when Mark was still at Houston Northwest. How's he doing? It went through 2 weeks, 3 weeks of people calling. How's he doing? Where is he now? Well, he's at Methodist now. And on and on, and up until we heard Mark died. When is the funeral going to be? Mm-hmm. It was literally a timeline, a verbal timeline of what this widow had gone through. And Jim may have some comments on it, but I don't know where I got that inspiration, but it sure worked. And when we played it, offered it at trial, they objected. And we had a judge. He hadn't been on the bench long, but he was a good judge. He's now on our Supreme Court. But when they objected, I suggested that we were offering it for the limited purpose, which is something you have to keep in mind, of course. Lawyers know. Offer for a limited purpose rather than a general purpose, and I offered it for the limited purpose of mental anguish. And what better evidence of mental anguish than these calls? And so we played it at trial. Nothing to see, just that recording. It was, in my opinion, very, very powerful. The other thing we did is we asked them to videotape Mark, who was now in Methodist, on a ventilator, and we had that video to play. We wouldn't have been able to do that if we hadn't got in on the case that early. And Jim may have some comments on those things too. Jim?
Well, I think the modern world, this case exists 15 years before the invention of the iPhone, right? But so when Dad talks about playing the tape, it literally was a cassette tape out of an old school phone message machine. But there is a palpable moment where the courtroom goes quiet and you have just that click play. And that is still achievable with a download out of an iPhone. That is still achievable with voicemails that are through some other system. The sound system was pretty functional, but it had that great crackly of cassette or vinyl that people still kind of long for. And you can still recreate that no matter what the source is, to get away from the idea that there's PowerPoint and there's visuals, but it was a 10-second phone message. Hey, I heard Mark's still in the hospital. And it is as Dad describes it. And I've had voicemails like this in more recent times where then you take them up and then there's a message. I heard Mark died yesterday. Mm-hmm. And then you have a few more on the other side of it. I remember included in the evidence, they brought us something as simple as, and this was 6 months after this man had passed, like a letter from a credit card company saying, to address to her dead husband. Just the subtle, never-ending reminders that come through modern technology that you're allowed to say, this never goes away for this widow, no matter how far past it is. And we were able to catch more than we weren't able to because the case came to us early, but we continued it all the way through, and even put in stuff like junk mail, which just was a very subtle.
I think that's just such a great way to do that because, you think about it when you're grieving and getting over the loss of a loved one, and then 6 months, 8 months later, something shows up and sort of just brings it all back. And then you relive that moment. And it's got to be especially tough on her. Yvonne, the thing I was thinking about in Georgia, I'm not sure we get that evidence in because, under the value of the life in Georgia, it's taken from the point of the view of the decedent, not, for the emotional loss of the loved ones that are left. But I love the concept. I love the concept of getting that evidence in if you can.
Yeah. And what you bring up is so important to keep in mind, which is that, you guys tried this case, you got this verdict in 1999. I think a lot of people can hear that and think now like, well, yeah, I'd take a video of my loved one in the hospital if I think something went wrong. But this is not when this is an easy thing to do. This is not when you've seen it done a lot of times before, where it's easy to sort of save that material. So I imagine that jury was so absorbed by the idea, by all the ways you presented the evidence, including the other things that we're going to talk about. But, it wasn't like juries now where there's just anybody wants to take and save a picture of anything at any time. We can all do it now.
Yeah.
But, it wasn't that way, even in 1999, I don't even know. I think like those disposable cameras that were like wrapped in, with the paper were like just starting in 1999. So anyway.
So Yvonne, so you're right. So in modern practice, what is your challenge as a plaintiff's lawyer? It's like, get me the pictures, give me all the pictures. And that for a 28-year-old is a massive download off their phone. But, a 70-year-old who has buried their 30-year-old son, even in my practice today, they don't have that, right? You have to go to the house and you have to get the printed 5x7s because the pictures matter. The pictures tell the story of the before. And we did a lot of dive into working through the before of Mark's life with his parents, with Lisa, and one of the things, but they did not have children, which is in a morbid fashion, which is the mortician humor of plaintiff's lawyers, is a valued negative, right? It reduces allegedly, but we had to find ways to power up the damage story through a variety of things, because you weren't going to have that heartstring of leaving behind young kids.
Yeah. I was thinking about, we have done in some cases, Yvonne, where, now, especially with technologies, you get if you can get the decedent's phone, find, text messages or voicemails that were left for them. And a lot of people will still do that even after they've heard that they passed on, just to sort of leave a memory. Yeah. And then obviously social media is a huge place where you can get stuff like that I don't know that we've ever really talked about before on the podcast, as far as, talking about who the lost loved one is.
Yeah. Well, and we have talked about, and it's a shame that in Georgia, I guess it can cut both ways, like we've talked about, but because in Georgia, it's from the perspective of the decedent. I think in all the wrongful death cases that we've tried over the past few years, you've basically gotten a motion in limine on it, for the parent or the spouse or whatever to not talk about the effect of this person's death on them, which is just so hard to do and so unnatural because those things are just intertwined
and just not real life.
Yeah.
So,
yeah.
But defense lawyers don't live in real life. So.
Exactly.
Let's go on with this case. So there's so many great things that you did in this case. One of the other things I saw that you talked about, and I was thinking about, how, whether or not you'd be able to get this, but two of the things that you did in discovery that I saw in this case was, one, you got what you were the comparables of the nurse anesthetist, which were her anesthesia flow sheets from other patients, it sounded like, so that you could compare that to what she had done that day. And then also, it sounded like you had quite the discovery battle on the machine memory strips from the machine itself. And then that became pretty useful in comparing what the CRNA was charting as opposed to what the machine was charting. Is that right?
Well, I'm going to let Jim talk about the comparables because actually I think we used them a little different than I stated in that book chapter you read. I'm glad I'm still editing it
right
before it goes into print. But I can talk about the memory strip. I think it's vital that a trial lawyer get as much into the case, and I mean really into it. And so this was an anesthesia case, and so I fortunately had some contacts at our Texas Medical Center, which is I think the largest in the country, maybe the world. And I went out, got with an anesthesiologist, and he took me into an operating room. And he had the anesthesia machine set up, and he went over how they work, how they're supposed to work, what the anesthesiologist or anesthetist is supposed to do. And I think I had a really good understanding of what we were dealing with, which I couldn't have gotten without actually going there. Then the next thing I did is I did a petition to perpetuate testimony because we were still early. I'm not sure we'd even file suit at that point, but we found out who this ghost anesthetist was. That's why, by the way, it's why my book chapter in my upcoming book is called, which is a theme we used throughout the trial, was death in the hands of strangers, because they never met this woman.
Mm-hmm.
Well, I took her deposition, and I took it by video, and I think video depositions are probably very common now, but I would tell anybody, and I know Jim would confirm this, if it's worth taking a deposition, take it by video.
Mm-hmm.
My God, when I started trying cases back when the earth was still cooling, all we could do is get transcribed depositions that we had to read to the jury. But now you can videotape it. Thank God we have that technology. This lady showed up, and I had them bring the anesthesia equipment that she used, and so that we could talk about it. And the poor lady, you ever had a case where you actually felt sorry for the person that really caused the harm? I mean, yeah. in a sense of, why did they end up in that position?
Yeah, definitely.
She should never have been in that position.
Mm-hmm.
But she was redheaded. She was kind of jerky. Had kind of a ambivalent countenance. Very defensive demeanor, very pleasant. She wasn't unpleasant. But, when you're trying a case, I do believe you've always got to look at it from the eyes of the jury. Never forget that. What are they seeing and what are they thinking? And I will tell you, after I got that deposition, forgetting what I was able to do on the facts, I don't think there's a person on that jury that would want her giving them anesthesia.
Mm-hmm.
And that was what we were trying to create, obviously. Well, it turned out that she didn't have a mastery of the monitors. And then what happened after that was that I knew that from my expert, I believe that's where we got it, that these modern machines have what's called a memory tape. That is, they tape everything that's going on. Everything the anesthesiologist or anesthetist sees is on a tape. And so after that, I was taking the deposition of one of the nurses that were in the operating room. And I asked her, do you know anything about memory tape? She said, oh, yes, Dr. Battaglia came in after this was over. He pulled the memory tape out and he put it in his desk drawer. I don't need to tell you how significant that is, because now we have evidence he had it. Mm-hmm. And now we have evidence that he still has it. It's going to be very hard to say I lost it, or hard to say it didn't exist. And so they couldn't do that. And we filed a motion for them to produce it, which they initially opposed, but eventually we got it, and we got the memory tape. The important thing in this case was, as the anesthetist is giving anesthesia, she's making notations of the vital signs. That's one of her primary duties. Keep track of the vital signs. And she has a chart she puts those on. That's the anesthesia record. The memory tape had vital signs, but there was a difference between time. If you went backwards from when he arrested, there was a difference in the time of 10 to 12, maybe even 15 minutes, which, if you compared them, would suggest that he laid there without a heartbeat for 10 minutes. And this was in face of the tachycardia he had, bradycardia. And let me just, now that we're here at this point, I'll just show you or demonstrate this, because this was very effective. We established this with one of our anesthesia experts. We, again, getting back to what we were talking about earlier about how sound, just sound, can be so powerful. This is what you hear when you have a heartbeat of 88 beats a minute, which was what we call his baseline. That's what he had when they started. Let's see if this doesn't work. That is a heartbeat at 88 beats per minute. His heart rate had dropped. She was monitoring it to 42 beats a minute. Now let's see how that sounds. And she said, yes, but I wasn't worried about that. This is what she said, that she wasn't worried about. So that's the evidence we had, and that's the way we presented it. Jim has written an article. I've got a chapter in my coming book about demonstrative evidence, and it is so powerful in trial. Anything you can do that's demonstrative. That's why, you can talk about what people can see. Yes, that's important. We do a lot of visual stuff. But think about it. We've got other senses. For example, what you can touch. What you can touch, we had the slide rule exhibit. They could touch it. Oh, but what about if you had an exhibit they not only can touch, they can manipulate, which is what our slide rule did. You could manipulate it. You could move it to check and line up those times where the jury could see it was 10 minutes before they even knew they had a problem. And so what you can manipulate, and then what you can hear. And during closing argument, I think I referenced how the operating room would feel and smell. It was cold. You could smell the Benedictine. You could smell the thing. The more senses we can appeal to when we're storytellers, if you're a real storyteller, the more you will get into having the jury not only know what happened, why it happened, but how it felt. And that's the key, how it felt. But I'm sure Jim has some comments that extend beyond what my poor meager mind's able to put out there.
I just want to say the metronome thing is so spooky. Like, I was trying to imagine what it would sound like, but hearing it here, it's so, I think first of all, I hate the sound of a ticking clock anyway. When I go home to my bedroom at my parents' house, they have a clock in there that I put in the closet every time I come home, because I'm like laying there in silence and the ticking of a clock, it's just like, it's awful. But for the same reason, how powerful, because you must have just had complete silence in the room, everybody listening to that sound. It gives me chills. That's all. I don't have a question. I just had to say that.
Noticed I worked that into the rebuttal I gave into the, and if we have time, we can talk about the difference between opening, which Jim did such an incredible job of, and rebuttal, because I used a nautical metaphor throughout my rebuttal, tying things into nautical. Being an old Navy man, I couldn't resist, but it was, I used it, I replayed it during a rebuttal and referred to it as an SOS, just like ships at sea.
Yeah.
An SOS signal. He was sending out SOS signals and they weren't listening.
Yeah.
Yeah, and you had not only that, and we talked about this briefly, but the alarms on the machines had been going off and then had been turned off.
Right.
So,
Right.
I mean, you had multiple SOSs going off with regard to what he was going through.
So Steve, you're making this case sound so damn good. How could anybody lose it? And
there are many ways they could be. Yeah.
The reality is that we were fighting a very tough causation case and some corporate and vicarious liability theories that we had to get to. But it's funny that the turning the alarms off created this dichotomy between the silence of what would have been available to her had she not set the low. I think and Dad basically says this in rebuttal, we know how this happened, but they set the low end parameter of the heart rate at 10.
Oh my goodness.
So that the alarm wouldn't go off. And so they were having problems with the alarms because there was variability. It was running high, and they come in and they just move the parameters for the pulse to such extremes that there's no way the alarm can sound. And one of those things that happens in trial that's unique is when we made a conscious decision about this, Dad and I talked about it, is we need some smart people on this jury, because this case can fall into the medical malpractice defense of nobody wanted this to happen. Everybody tried, their best. Nobody's perfect, but these are healthcare providers, and the last thing in the world they would ever want is to have a patient suffer a bad outcome. And we hear this all the time in jury selection in med mal. I know this is true in Georgia. It's true everywhere in the country as well. Unless the doctor was intentionally negligent, I don't think I could find him or her responsible. I'm like, well, yep. I still haven't seen intentional negligence, right. But when we get that standard, and that's tough, right? And so one of the things Dad always taught me, which is if you're not up by 42 points at halftime in a med mal case and you rest, you're getting ready to get your butt kicked in the second half. When they start moving the ball on the other side of your resting, it is a difficult thing to hold from the plaintiff's perspective when you're doing med mal. So we actually took, and this is counterintuitive and it's worth adding to the conversation. We had a vice president of a bank, and we had an engineer at a oil and gas firm on this jury that we actually intentionally didn't strike. That is a high wire act from the plaintiff's perspective of the highest order, but we intentionally said, I need some people who will understand the concept of damages, but also be able to parse through the science. And I'm comfortable with somebody who will apply kind of the principles of order. Plaintiff's lawyer 101 is to get off the engineers, right? I mean, engineers are just such bad plaintiff's jurors, but we did it. And part of this conversation is a reminder that sometimes you've got a case that does require somebody in that room, in that dynamic of 12 going, it cannot happen the way the defendant said it.
Right.
Mhm.
Right.
And we found out post verdict that that's exactly the way it went down.
Yeah, and sometimes you just have to do that. I can remember a case that we tried where we had a friend of ours come watch us pick a jury. It was a products case, and we left 2 architects on there, and he was an architect, and he's like, I don't know if you want to leave those architects on there. They're usually, really conservative. And our thought process is, well, they know rules. They know rules, and if you don't follow rules, what happens? And they were really good on it, and it turned out well. One thing I didn't mean, Jim Jr., to make this sound like this is like a slam dunk case. It certainly wasn't. One of the things that I should point out was that, or at least that I saw, was that the defendants had hired what looked like 4 different pathologists and did multiple, after the autopsy of Mark Alexander, did multiple slices of the heart, and then basically came up with this defense of idiopathic fibrosis, and that this was sudden death, and that essentially Mark Alexander was going to die immediately at some point, and it just so happened to happen when he was there on the operating table. Is that basically what they were arguing?
Yeah, but Steve, even when you pitch it that way, you do sound like a plaintiff's lawyer.
Well, I am a plaintiff's lawyer.
That defense, when it comes from you, sounds as incredible as it does to us.
Yeah.
They said an epinephrine wash that Dr. Stewart had used had caused this. They said when Dr. Stewart, Jim, you remember all this? They said that when he pulled on the sutures that he was on the shoulders, that triggered the heart. But it was all based on this idiopathic fibrosis. They said that was a defect in the heart. And I traveled, I forget, it was a long way away. I remember that, a long plane ride to one of the experts they hired way up somewhere. And with some difficulty, I got him to give it up. And we played a short excerpt from his deposition at trial, which pretty well shot that down.
I'm sorry, I don't mean to interrupt you, Jim. I just wanted to clarify, because I don't think I said in this in the beginning, that Dr. Stewart is the surgeon who was performing the surgery. Was he involved in the case at any point? Or was it clear fairly early on that it was going to be more useful for him to just be telling y'all about what happened? I know he did some stuff at trial that I want to make sure we talk about, but did you ever think about bringing him in the case, or was it pretty clear that he didn't really have a responsibility?
Well,
this was not an orthoscopic surgery error.
Right.
It was very clearly early on. This was a respiratory compromise leading to an anoxic brain injury. And orthopedic surgeons may get dismissed as carpenters, but that carpenter had nothing to do with that brain damage.
That's right.
We needed to keep him friendly, because he was going to be, and maybe we'll get time to talk about that, but we needed him friendly, and he became a tremendous witness for us because of the way we presented him.
Yeah. Well, let's talk about that. I mean, let's talk about what y'all did with him at the trial, how you were able to use his testimony in such a powerful way.
Well, we did something that is, I will tell you, it goes back to a great trial lawyer by the name of Earl Rogers. And I don't know if you've ever had any of your people on your show talk about Earl Rogers, but he was the greatest criminal lawyer in California back in the 1920s. His daughter, Adela Rogers St. John's, wrote a book that I read, I think, when I was probably just starting practice law. And he was an innovator in so many things that people are using now, like telling part of your argument, telling it in the first person. He did that, but one of the things he would do is he would recreate one of his big criminal trials was involved a shooting at a poker game, and he set up in the courtroom a facsimile of the poker game and where the people were sitting. And so what we did in this case is we knew from talking. We had, I think, taken his deposition, but we set up in the courtroom a facsimile of the operating room. And we set up tripods and brought a sheet from home to recreate the operating room table, because in the operating room, the patient is laying, they turn him on his side through the surgery, and then there's a sheet that separates the doctor, the surgeon, who is really looking at a monitor and manipulating instruments, and the anesthetist. And we took him into the present tense. We asked him, can you take us there to the operating room? Can you take us there that day? And now keep in mind, I hadn't prepared him. I mean, we didn't go through this ahead of time, but he knew that we had treated him fairly, and he was going to be fair with us. And so he did, and we got him talking in the present tense. And we were asking questions in the present tense. Who is there? Not who was there. Who is there? Where are they standing? And we led up to the drape being shaken. And I said, can you show us what's happening? And he took the drape and he shook it. And what is happening now? Not what happened next, what is happening now? He said, I asked the nurse anesthetist, what is going on? And she replies, I'm not getting air in one lung. And then they stop the procedure and they turn him over. And he is blue. His face is blue. His trunk is blue. His legs are blue. He is blue. That is advanced cyanosis. He has been deprived of oxygen. They were saying they got it right away. They got right on it. You don't turn that blue unless you've been without oxygen for 10 or 15 minutes. He's already brain damaged. He's already dead. So we use that technique to create drama and suspense and curiosity. Powerful, powerful techniques, but Jim may have a different view of it.
No, I don't. It was, we actually got a hospital gurney into the courthouse. We brought it up in the freight elevator, and we did, it was amateurish after that point. We had an actual hospital gurney to recreate the bed, but that was really, the jury got it. And it was, and from there it was our own bed sheets that we brought, and we clipped them to easels. And it looks like I've been at the presence of 3 cesarean sections of each of my boys. I mean, it looks the
Right.
exact same. We had it kind of draped up, and we owned or we had leased an anesthesia monitor, and we had that in the courtroom because we were using that constantly anyway. So we had him configure it exactly as Dad describes it. And the end point of that, and again, because he was not our witness, and we did not want to be in a position of anybody alleging that we were working with him. He was the surgeon. He was not friendly to us, but he was not happy about how this happened. But he gets to the moment, and small digression. I honor the people from Trial Lawyers College and psychodrama work, but this was first person courtroom direct examination by a witness who had not had any work done with him on it. But he was able to go there in that mental recreation because it obviously meant a ton for him. And we got him by the third question in the present tense. The witness then had lost the tendency to go back to past tense. He stays in present tense with the questioner, and it is now active there. And I remember the end point, which was I'm pulling the drape back, and I look down, and Dad says, "What are you seeing?" And he says, "It looks like he's been outside on a freezing night for a long time."
Wow.
And that was just Stewart's own analogy for what he saw. You can't like script that, right? It's just,
Right.
it's the ability to kind of get them in the access to the real memory that is done through that work with present tense. You can call it psychodrama, you can call it a lot of different things, but that was done with no prep in a courtroom. And it was because of the equipment and the setting and then the language that was used that we were able to recreate that.
Yeah, that's great. I'm curious on just from a trial lawyer logistical standpoint, like the gurney that you had, did you guys go and buy that, or did you borrow it from a hospital, or and then you said you leased the anesthesia equipment. How did you obtain all that stuff?
So I remember that because I was bottom of the totem pole when we tried this case. All that stuff went downhill. So I remember I had to figure out how to get the hold of the anesthesia machine, and that really was there was a medical supply company over by the medical center, and it was the exact same one. And I don't think we bought it. We were able to lease it somehow for 2 months. The gurney we took on loan, like as a favor from somebody we knew that had a nursing home or something. I don't remember the details of it. We were like, "Can we have a hospital bed for 2 days?" And they were like, "Sure, we like you guys."
Yeah.
So
That is great. That is great.
Wow.
One of the, oh, go ahead.
Well, Steve, I don't want to get us off track, but we talked about it a couple times, and I feel like it's related to what we're talking about. And then we're talking about the different things you all did demonstratively. And we mentioned the slide rule exhibit a couple times. And I just want to make sure that you all describe what you had put together, because I think you had done it with the intention that it would be, once you could get it in, that it would be something really helpful for the jurors that the jurors would really engage with. And you learned later that it was basically the first thing they did when they began their deliberations. But I'm just hoping you can explain what it was for our listeners.
Well, it was about, of course, I'd say 3 feet long, wide, 2 or 3 feet tall, and it was what it was the numbers from the vital signs from the monitor on one slide that you could slide, the numbers from the vital signs from her written record she prepared that you could slide. So you could slide them and you could line them up, and which worked real well going into closing argument, because there were one blood pressure that was kind of an unusual blood pressure. And if you lined those blood pressures up, is where you could demonstrate, and I know y'all have read the closing arguments, but you could line them up, and you would see, if you lined them up, that he had laid on that operating table for 10 minutes at least without a heartbeat. And so the interesting thing about the slide rule, I tried to get it in with our experts, and the defendants objected. At least this is the way I remember it, Jim. The defendants objected, and then they put on an expert. And when they put on their expert, I said, "Tell me the things you've looked at to form your opinion." And he mentioned them, and I said, "Well, what about this? Did you look at that?" "Yes, I looked at that to form my opinion." "Well, it's in." I offered it in evidence. I think as part of their case, that's when I got it in.
No, it's better than that. It was the ultimate arrogance of a defense expert. So Dad's like, "What did you look at to come up with your opinions?" And he says, Well, I really enjoyed your slide rule concept because I was more than happy to use that. And dad's like, so you liked it? Said, I loved it. I used it a bunch. Said, did you rely on it? And he is now just hooked,
Yeah.
right? He's like, I absolutely relied on that coming up with my opinions. That happened in the first 5 minutes across. And the defense lawyer is losing his mind, but man, he was more than happy to go in that intellectual rabbit hole. And it was done because after he said that, Dad turns to the judge and says, Judge, I'm going to reoffer plaintiff's exhibit 51.
Yeah.
And the judge says, it's in.
Yeah.
Let's go.
That's awesome.
That's great. One thing that we haven't talked about and the theme that I like that you developed was that when the CRNA started noticing that there were some issues with regard to the vital signs, her first instinct was not to check the patient, but was to start messing with the equipment. Can you talk about that a little bit, about what she did after she noticed the vital signs were not where they should be?
Why don't you take that one, Jim?
Well, so to kind of give the listeners a sense, I mean, the slide rule became an issue because we have this memory strip that is kind of unquestionable, right? It is data straight from the machine. And then we have the handwritten anesthesia record. And I increasingly see this in med mal cases. If you can compare it to kind of a baby case, you've got the fetal monitor strip. Most of the annotations now are directly into the computer system related to the fetal monitor strip. But there used to be a time, right, where as the paper came out of a fetal monitor machine, a nurse would circle an area of question about what the tracing was showing, or they would make a note. And you needed to get that paper strip to be able to correlate it, because the pure what's in the machine is not telling you what the nurse is recording about his or her thought processes while it's coming out of the machine. And that bedside nursing dynamics. So imagine stepping back a decade earlier, where you've got an anesthesia record where the nurse is basically just looking at a diastolic, a systolic, a diastolic, and a heart rate, and she's writing those down on an old school anesthesia record. But we find there is actually a strip inside the machine that doesn't come out in real time normally, but they can go back and get. And that was kind of the discovery in the case that kind of tipped, and we had this second piece of evidence that could show that the anesthesia record was a fiction. Because there was no way to correlate what she was charting with the times she was charting it to the reality of when the code was called. Their defense to the case was the code was called within 9 minutes of her recognizing, and that there was an interval time according to the standard of care that you would miss the drop of an absent heartbeat. And they called the code immediately when she realized that he had gotten into such bradycardia that he actually had a cessation of the heartbeat. The reality was the strip, when you compared the blood pressures, would show you he did not have a heartbeat for, and Dad's wrong about this, 20 minutes before they called the code. And it was the slide rule that allowed you to lock up the numbers. So the constant, if you imagine the axis in the middle, is only, it has nothing to do with time. It has to do with events. It has the time of the called code, and it has the time of the heartbeat stopping as a gap, but it's not tied to time. Your time axes are on the top and the bottom slides of the slide rule. So you line those up, and that's when you realize she's missing the absence of a heartbeat for 20 minutes before she calls the code. And so, Steve, to your point, and this is a system error that I've used as an analogy multiple times since. Malpractice cases don't happen because one person makes a mistake. Usually there are multiple people making multiple mistakes of errors. An airplane does not go down generally because of pilot error. And The only way an airplane crashes is because of multiple systemic failures. And more often than not, they have to do with the human individuals questioning the data they're getting from the equipment. The data they're getting must be a machine error. So they spend 5, 6, 7 minutes going, the machine can't be telling me that. That can't be right. Mm-hmm. And so she spends 7 or 8 minutes figuring out, why is the machine telling me that I'm getting 50/30 blood pressures with a heart rate of 22? And by that point in time, right, he is completely being oxygen deprived until he finally gets to a bradycardic arrest. And so the alarm is not going off because they've put the alarm parameters to the point they won't go off. But just like a pilot who flies into the side of a mountain, it's like, well, that can't be right as far as my altitude. Change. Well, where are we, right? And something has to be going wrong. Next thing you know, they're inverted and they put it in the Chesapeake Bay. The same thing is going on with this person. She is looking at the machine going, the data I'm getting can't be right, as opposed to trusting the data and dealing with the clinical signs of the patient. And that actually did appeal that appealed a lot to the oil and gas engineer, right? Is you trust the data first and work the data to solve the problem before you begin questioning the data as your solution pathway. And that was what explained the differential between them allegedly calling the code when she figured it out versus what the slide rule proved, which is she had no heart rate for 20 minutes before she called the code. And that analogy, I think, works. It's different cases where you can take it to, but the idea essentially is for any safety process, you need to trust the data first before you question the machine. Take care of your patient before you question your machine. We see this in baby cases. I'm sure you, Yvonne and Steve, have seen that in baby cases, right? It's, well, the strip is not, telling me that. Certainly there's something else that could be done. And we had that exact same thing here in an anesthesia context.
Yeah. One thing I wanted to ask before we move on to another subject is I noticed that the CRNA, after Mr. Alexander's taken to the hospital because he's in a coma, and the family asks the surgeon or is talking to the surgeon, and he doesn't even know who the CRNA is. And the CRNA had gone home, but was supposed to come back in a day or two to fill out a report, but then never came back. And I guess I was just wondering, did the CRNA basically quit being a CRNA or just completely quit the job after this event?
I think she kind of disappeared, but they did produce her when we subpoenaed for our deposition of her. I want to mention one thing about malpractice cases in Texas. They are very, very difficult to determine what happened, and the reason is, and they did that in this case. We have in Texas what's called a hospital committee review privilege.
The peer review privilege or something along those lines?
Yeah, it basically says that if the hospital looks at an event after it happened, investigates it, you cannot determine what they determined.
Yeah.
You can't see it. And so we're always running into facts, evidence that would help us, but they claim it's privilege. Now think about it. Jim's talking about airplanes going down. If you lose a loved one in an airplane crash, the FAA is going to investigate, and you can get that. If you're injured in an industrial accident, OSHA is going to investigate that. You're going to get it. A lot of plaintiff lawyers base their cases on those investigations. If you're in an auto wreck case, In Texas, the highway patrol, the local police are going to investigate that accident. Just about any way you can get hurt, somebody investigates, and as a plaintiff lawyer, you can get that information.
Mhm.
Not in a hospital.
Yeah.
Not in a hospital. And so you have to kind of really start from with a blank slate and dig it out yourself. It's not easy.
Yeah. And you know, I mean, if we really want to get into a discussion of the peer review privilege, I mean, I think it's routinely abused by the defense. I mean, it's they call everything peer review, but it's something to me that's outdated. It needs to go away, and you know, so that people can have free access to what happens in their medical care. But I
and I mean,
absolutely agree.
An example is what that was initially, it sounded like at least an argued basis for why they didn't want to give you all that memory strip was peer review, which
Right.
it's, how was that peer review? That was happening at the time of the event.
Right.
Yeah, we went up on mandamus on that.
Really?
Yeah.
Really?
Yeah.
Oh my gosh. My blood pressure's I'm just flashing back to so many meet and
I
confers.
gotta tell you, so Dad and I have tried a case in Georgia, and I've never heard a jury charge more miserable than the one that's read to a jury in a medical malpractice case than the one I heard in Atlanta, Georgia.
Hindsight charge, yes, yeah.
That said, I still would rather practice in Georgia.
Right, yeah,
right.
Exactly.
Yeah,
No,
our charges, when you read them, when you put them all together, when you put all the medical negligence charges together, you're like, how does anybody win these cases ever?
Yeah, exactly. Well, you know, we haven't really talked about, you know, I mean, two issues that I want to make sure that we talk about. One is Jim Jr. We talked about this before. You did go up on appeal after this verdict about the issue of whether or not the anesthesiology practices were directly responsible for what happened. And if I can just briefly say it, the two anesthesiologists, Dr. Battaglia and Dr. Polk, had professional associations that were provided anesthesia. Neither of those doctors actually treated Mark Alexander, from what I recall. And so there was an argument that their PAs shouldn't be held responsible. And you were successful in finding direct negligence against the PAs and then holding that up through the Supreme Court. Do you want to talk about that a little bit?
Yeah, Steve. So Senior deserves credit because he really did help write the law of Texas medical malpractice until the legislature undid everything he did during a 30-year career up to that point in time. But the unique aspect of this case, when it comes to kind of one of the challenges at trial, so we've talked a lot about liability to the CRNA, who just completely blows it. Single lung intubation combined with an esophageal stethoscope that fails the cuff. So you don't have a good seal with a cuff because their esophageal stethoscope is down into the lung, and you've got a one lung intubation. That's a recipe, right? That's the systemic multiple failure facility that's trying to do 7,000 procedures a year with basically 2 anesthesiologists managing 7 CRNAs and 7 different ongoing operating rooms. That's a systemic failure. So the corporate liability theories that we had to put together to be able to maximize the potential recovery, because the hospital, I mean, this was unique in that the CRNAs were employees of the anesthesiologists. They were not the CRNAs were not hospital employees. So we did not have a vicarious pathway to the institution based on the negligence of the CRNA. That then led us to discover the theory that the anesthesiologist had this exclusive contract to provide anesthesia services. So the appellate issue, which was dealt with and affirmed, and I will say by an all Republican Court of Appeals, was no, the Perdue's did produce evidence of direct negligence against the PAs And our theory was that the contract in and of itself, the contract that was executed by the professional associations, said these two professional associations shall provide anesthesia services to the outpatient facility that complies with all governmental, state, and anesthesia standards of care. So we basically got to ANA standards through the contract that created a standard, not just of supervision, but the delivery by the CRNA. That was our theory through our expert of direct negligence against the PAs, created by the contract, tort duty, affirmed by the Court of Appeals, and then affirmed by the Texas Supreme Court. And the interesting end note to that is Priscilla Owen wrote the opinion of the Texas Supreme Court. For your listeners who know anything about the Fifth Circuit, Priscilla Owen was one of our most conservative Texas Supreme Court justices. And the last opinion she wrote on her way out the door to the Fifth Circuit Court of Appeals, where she is now chief of the Fifth Circuit Court of Appeals, which is the most, I don't know, the 11th maybe in competition.
It's close.
Right, yeah.
But between the two of them, that competition is always close, but she is the chief of the Fifth and a very, very conservative jurist. But her last appeal on the Texas Supreme Court was affirming our verdict and our direct negligence theories against these two PAs. But we built it out of the contract, Steve, and then the evidence came out of combination of experts, ANA standards, and just the evidence of the case of her being so incompetent. There's no way you're complying with that contractual duty, which is a tort duty for undertaking to provide anesthesia services. And that's very legalistic, but that's the way we got to them. And then I know Georgia's a pure comparative state. We had pure comparative, and I believe we told the jury to put 30 on the CRNA, 30 on the supervising, and then 20/20 on the two PAs, and they did exactly that.
Yeah.
I mentioned one thing real quick too. It's more of not as cerebral approach as Jim would take, but then I'm less cerebral. But the standards he's talking about, one of those standards that they said they'd abide by, provided that when you give anesthesia or medical care at TOPS, that the patient is has a right to know who's doing it, who's providing the services. And that's how we got our theme, death at the hands of strangers, because they never met this lady.
Yeah.
Never met her. And that's why for those people who are maybe not lawyers that listen to this show, if you're going to have surgery done, always say, who's giving me the gas? Who's giving me the gas? And you want to be sure you meet them, and be sure, by the way, that who's giving you the gas is a real MD anesthesiologist, not a CRNA. I'm not putting down all CRNAs, but there is a difference in the training and experience from an anesthesiologist than CRNA.
Yeah.
It's just another case. I mean, it's such a common theme, and I don't know how much you all had to hit it in trial, because you had so many other themes that you could work with and so much powerful evidence that you could work with. But it just always makes me go back, Steve, to just thinking about how the betrayal of trust that in these cases, but especially the medical negligence cases, and the idea that a lot of people, especially non-lawyers, people maybe who don't have medical professionals in the family, they think everybody that's going to be doing anything for a procedure is a doctor. They think, they don't even question or whatever. I don't know if I knew that CRNAs could do that much stuff related to anesthesia before reading about this case.
Well, and it can, when you go in for any kind of procedure, but it's, outpatient procedure, it can be very overwhelming to the patient who's, basically out of their element. And then they have all these different people come in there, ask them all kinds of questions, prodding them. I mean, from their standpoint, they want to get through this as quickly and as safely as possible. But, they're trusting all of these different people that are walking in the room.
Right. Well, and you think about when you're in the hospital, which I've only been once, but it was as a grown up and as a lawyer who had done medical negligence. And even I found myself like, there was so much stuff that I mean, I was sick, but there was so much stuff that I didn't ask about or push back about because I just like wanted them to like come when I actually needed them. And I didn't want them to hate me.
Right.
That I'm like, no, man, that was not the right approach. You gotta be the squeaky wheel. Ask all the questions.
Along those lines, I wanted to make sure we pointed out to our listeners another theme that it might have been you, Jim Jr., that made this in one of the arguments that that you talked about. That I think you had just been married, maybe a year or two before, and you talked about the oath that you made to your wife on that day, and then talked about the oath that other professionals make, like when a pilot makes an oath that gets you there safely, and then the oath that a doctor takes. And and I really like that sort of bringing it all together of that when they bring you in there to do treatment on you, especially when you're going to be completely unconscious, that they're that you're putting yourselves in their hand, and they're taking an oath to do the best they can by you. But I like that theme is what I was pointing out.
Well, thank you, Steve. I think they say you write what you know, and as a trial lawyer, you attach the emotion to what's present for you. And I was pretty newly married, didn't have children. But if I may, because this is not a story for Dad to tell, he's somewhat humble about it. That dovetails into something that overlaid this trial and says a lot about my father, and I think probably says a lot about the trial and the verdict, because it flows through all of his honesty and presence as an advocate while he was trying the case. This trial date came up, and my father's 10-year relationship got diagnosed with ovarian cancer and went into the hospital. We tried this case over 3 weeks while his fiancée was dying of ovarian cancer in Methodist Hospital. So when we talk about these trial days, literally, Steve and Yvonne, our day would end and we would go to the hospital. I would sit in the hallway and read transcript, and Dad would sit at the bedside of his fiance, and we did that for the first 2 weeks of trial, and then she passed on November 1st. We closed on November 3rd, and we took our verdict on November 4th. I took the verdict because Dad was actually at the funeral home with my wife. And I called him and I said, we have a verdict. And Dad was terrified because he thinks it's way too soon. We're not going to win with a verdict that's come back that fast, because they hadn't been out at that point, 6 hours. And they came back with this verdict, and multiple of them asked how your father's doing because they had read the obituary in the paper that day. Now, that sounds a little jaded, but I think it was from a place of empathy. I think most people ask for a continuance under that circumstance, but Dad, as a lifetime advocate and somebody who was very connected to this family, couldn't see himself getting out of this trial date. And the reason why this case, I think, will always be as important to me as any is that the life story of it and the microcosm of what was going on outside of the courtroom and what we were dealing with on a daily basis. And for him, literally he was making funeral arrangements the day we had closing.
Oh my God.
And we went through it, and we had these clients came to the funeral, and we had 2 jurors come to the funeral.
Wow.
And I think that is a statement to, while I would question my dad's psychology for being so committed to the practice of law and the profession of law that he thought he could get through that grief by burying himself in the work. there's an honor of burying yourself in some way and fashion in the work. And I will tell you that Joan, who we lost, honored him for burying himself in the work and not just, I mean, what do you do? Sit up at the hospital for 10 hours a day. And I don't be dismissive of that, but Dad buried himself for work, not to distance himself from the grief, but to have something to be done. And we buried his fiance 4 days after this verdict, and went through it. And it's a testament to him and his commitment to the profession. But I think that those people came to that funeral and wanted to be with him was because there was a pure honesty that flowed through the way he presented the case about this loss, because he was going through the exact same thing. You talked about a little bit of kind of the, when it comes to the voicemail or the damages, but there was a, when I look back on it, a purity to his advocacy that was, Dad's a great advocate, but there was a purity in it because of the suffering that he was going through and literally, you know, the day of. And so ultimate professional, but for what it's worth to those that would say, you know, I could or wouldn't or whatever, or that's a wall against grief. I would say that, you know, there is something to be said for throwing yourself into it and being honest and doing the work, even in times of challenge. And this verdict says a lot about Dad and his commitment to that.
Yeah, well, that is incredibly moving and powerful. And you know, not only commitment to the work, but a commitment to your clients. I mean, because, you know, it's hard, you know, at least nowadays, hard to get your cases to trial. So, you know, when you get them there and you've poured your heart out in the courtroom, you don't want to, you know, you don't want to let that go for your clients. You want them to have their day, and they want to have their day. But that's just, I don't, you know, I you know, hope I never know anything like that. And I can't imagine how you got through it. But it does speak volumes about your commitment and your advocacy. And I'm so sorry for your loss, Jim Sr.
Well, one thing it teaches you is when you lose somebody dear to you, I don't care what people say, you don't get over it.
Yeah.
If not a day goes by, I don't think of John.
Yeah.
But I will say one thing: we live in a small world, us lawyers, but there's a big world example that I kind of like to keep in mind. You may not know this, but when Abraham Lincoln was about to leave to go give the Gettysburg Address, his son Todd, his youngest son, got very sick. They weren't sure he was going to live. And there was questions whether he should make that trip. And when he left the White House, they thought Todd was going to die. He wrote that Gettysburg Address while he was thinking his son was dying in the White House. But he still made the appearance, and he still gave 2 minutes of greatest speech in English language, probably.
Yeah.
And he did it under those circumstances, and they asked him how he could do it. He said, because I needed to be there. I was trying to save the country. Well, we lawyers can't save the country, but sometimes we can save our clients.
Yeah. Yeah. Well, I mean, this has been just a great interview. I really appreciate your time. I want to make sure or remind everybody, we've been talking about the Alexander versus Crowder Battaglia Polk case that was tried in 1999 in Harris County, Texas, for the death of Mark Alexander, and resulted in a $3.6 million verdict. Is there anything about that trial that you want to make sure our listeners know about that we haven't had a chance to talk about?
I would mention one thing that might I know y'all will be sending, I think, written things they can read, the things I assume we sent you.
Yeah.
One thing about storytelling and trial advocacy, one of the things Jim mentioned, I think Yvonne asked him the difference between him and me. Jim is very smart, and I believe that when you do your closing arguments, plaintiff, we get to make 2 arguments, and they ought to be different. They ought to be very different. Your opening is really your cognitive argument, what I call cognitive, rational, reason, cerebral, logical. Jim is great at that. I mean, if you read his argument, you can see it. And it is an argument to tell people how to build their verdict, how to build their verdict. Rebuttal, a lot of lawyers think rebuttal is when you get up and answer what the defendant said, and it is so wrong to just get up and try to answer everything they say. I taught my students, don't do that. Don't do that. Pick out something they say that you can turn against them. Don't try to answer everything. And rebuttal argument is an effective argument. When you open argument, it's telling them how to build their verdict, but the rebuttal ought to tell them why they ought to build their argument, why they ought to return that verdict. And so it is, you can call it emotional, you can call it effective, whatever, but they're 2 different arguments, 2 different reasons, 2 different approaches.
Yeah.
And that is why when we tried cases together, he always got rebuttal.
Right, exactly. Well, I mean, this has just been such a pleasure, and I really have enjoyed having both of you on the show. I want to remind everybody we've been talking to Jim Perdue Sr. and Jim Perdue Jr. You can look them up at perdueandkid.com out of Houston, Texas. That's PERDUE and spelled out KIDD.com. Jim and Jim, thank you so much for your time. We really appreciate it.
Thank you for inviting me. Thank you for inviting my son.
Absolutely.